Assalamu alaikum aspirants. Welcome to our next video of this lecture series of international law where I am covering international law according to syllabus of CSS and PMS. Now with this I come over to the next topic, which is effectiveness of international law. Now coming over to the outline of today's topic. First of all, in the introduction part, I will start with the definition of international law, and then I will enlighten you with the importance of studying the effectiveness of international law. Further moving on, I will explain the theoretical approach of international law such as realism, liberalism, constructivism, and critical legal studies. Then I will discuss the challenges to the effectiveness of international law, that are sovereignty, lack of enforcement mechanisms, compliance and implementation issues, power imbalances, and cultural differences and competing values. Now stepping ahead, I will give some examples of effectiveness of international law, which includes International Criminal Court, International Court of Justice, UN Convention on the Laws of Seas, International Human Rights Treaties, and International Environmental Agreements. Moreover, the role of states in the effectiveness of international law will be explained briefly, such as the duties of states to comply with international law, the role of states in promoting and enforcing international law, and the role of international organization in facilitating state compliance. And at the end, there is an actual question arise, which is international law effective in nature? And then I will be concluding my topic. Let us start the topic with the introduction. First of all, the definition of international law. International law is a set of rules and principles that govern the relations between states as well as other international actors, such as international organizations and individuals. Now, the importance of studying the effectiveness of international law. The effectiveness of international law determines its relevance and legitimacy. The more effective international law is, the more likely it is that state will comply with its rules and principles, leading to a more stable and peaceful world order. Coming over to the theoretical approach to international law. Now, the first theory which I am going to discuss is realism. This theory argues that states are the principal actors in the international relations and that international law is only effective to the extent that it serves the interest of states. Now, liberalism. This theory emphasizes the importance of international cooperation and the rule of law in promoting peace and stability in the international system. It sees international law as an essential tool for achieving these goals. Now, constructivism. This theory argues that effectiveness of international law is shaped by social norms and shared values among states and other international actors. And the last one is critical legal studies. This theory critiques traditional approach to the international law, arguing that it often serves the interest of powerful states and reinforces inequalities in the international system. With this, I come over to the challenges to the effectiveness of international law, in which first of all, the sovereignty. The principle of state sovereignty often conflicts with the goals of international law, such as protecting human rights or promoting global environmental sustainability. The second is the lack of enforcement mechanisms. International law lacks a centralized enforcement mechanism, which can make it difficult to ensure compliance with its rules and principles. Then coming over to the compliance and implementation issues. Even when state agrees to abide by international law, they may struggle to implement its provisions effectively. Now, power imbalances. Powerful states may be more likely to ignore international law or use it to their advantage, which can undermine its effectiveness. And the last is the cultural differences and competing values. Different states and cultures may have different values and priorities, which can make it challenging to establish a shared understanding of international law's importance and effectiveness. Now coming over to the example of effectiveness of international law, which are International Criminal Court. The ICC is an independent judicial body that has the power to investigate and prosecute individuals for international crimes such as genocide, war crimes, and crimes against humanity. Its existence and activities demonstrate the effectiveness of international law in holding individuals accountable for their actions. Then the second is International Court of Justice. The ICJ is the principal judicial organ of the United Nations and hears cases on a wide range of international legal issues. Its decisions have helped to clarify and strengthen international law. Then the next is UN Convention on the Law of Seas. This treaty has helped to establish rules for maritime activities and have resolved long-standing dispute over maritime boundaries. Then international human rights treaties. These treaties establish international standards for protection of human rights and have helped to promote human rights globally. Then international environmental agreements. These agreements establish rules and guidelines for protecting the environment and promoting sustainable development. Now with this I come over to another part, which is the role of states in effectiveness of international law. The first role is the duty of states to comply with international law. States have a legal obligation to comply with international law, and their failure to do so can lead to consequences such as economic sanctions or military intervention. The role of states in promoting and enforcing international law. State can promote and enforce international law through diplomatic efforts, participation in international organizations, and the establishment of domestic legal frameworks that align with international law. The role of international organization in facilitating state compliance. International organization can also play a key role in facilitating state compliance with international law. Organizations such as UN can provide forum for states to discuss and negotiate international laws, and can provide resources and support for enforcement mechanism. Now coming over to the gist of this topic, which is international law effective in nature? International law is generally considered to be effective, but its effectiveness can vary depending on the specific context and the issues it is being applied to. On one hand, international law has been successful in achieving many of its intended objectives. For example, international law has played a critical role in maintaining peace and security in the international system, resolving disputes between states, and protecting human rights. International law has also provided a framework for cooperation and coordination on a wide range of issues, including trade, environmental protection, and health. On the other hand, international law can be limited by a number of factors. The effectiveness of international law is often influenced by the willingness of states to comply with their legal obligations. Some states may view international law as a constraint on their sovereignty and may be unwilling to comply with its rules and norms. The availability of appropriate enforcement mechanisms is also important for the effectiveness of international law. Some areas of international law, such as human rights or humanitarian law, may not have effective enforcement mechanism in place. International law is also limited by the fact that it is a volunteer system and it relies on states' compliance. It does not have the means of enforcing the law on its own as a domestic legal system does. Now we will be covering each aspect with different examples. So our first example is, international law has been successful in preventing the spread of nuclear weapons through the Nuclear Non-Proliferation Treaty. This treaty has been ratified by over 190 states, and it has helped to prevent the spread of nuclear weapons to many countries that do not possess them. Now the second is, international law has played a critical role in resolving dispute between states, such as International Court of Justice, which settles dispute between states through legal means instead of military means, which have led to devastating consequences. One such example in the ICJ's ruling on the dispute between Bolivia and Chile over access to the Pacific Ocean. Now the third is, international law has been used to protect human rights, such as Convention Against Torture, United Nations Convention Against Torture, and the Convention on the Rights of the Children. These conventions have been ratified by many states, and they have helped to improve the human rights situation in many countries. Now coming over to the limitation of international law and its effectiveness. So here we will be discussing different examples, such as international law has been limited in its effectiveness in addressing issues such as ongoing conflict in Syria, where multiple states has been unwilling to comply with their legal obligation under international humanitarian law, and the lack of an effective enforcement mechanism has made it difficult to hold those responsible for war crimes and crimes against humanity accountable. Now the other example is, in the United States, international law has been limited in its effectiveness in addressing issues such as climate change, where the US has withdrawn from Paris Agreement, and the lack of political will to take meaningful action to combat climate change has made it difficult to achieve the goals of the agreement. And the third example is, in China, international law has been limited in its effectiveness in addressing issues such as humanitarian rights violation in Xinjiang, where government's strict control over information and lack of cooperation with the international community has made it difficult to hold those responsible accountable and to improve the human rights situation in region. So coming over to the conclusion part, in the nutshell, the effectiveness of international law can vary depending on specific context and the issues to which it is being applied to. International law has been successful in achieving many of its intended objectives, such as maintaining peace and security in the international system, resolving disputes between states, and protecting human rights. However, it can also be limited by a number of factors such as state compliance, the availability of appropriate enforcement mechanism, the political and economic context, and the perceived legitimacy of the international law. Examples from various countries such as Pakistan, India, China, United States, and Russia highlighted that international law has been successful in many areas and limited in others. It is important for international law to continue to adapt and evolve to address new challenges and to ensure that it remains effective in achieving its intended objectives. With this, I come over to the end of my topic. So keep on watching and stay updated. I thank you all.